it. Over $111 million. And I'm going to tell you why, exactly why we're having to cough out this amount of money and what has resulted in it, exactly why we should all be concerned about the state of affairs. Things cannot certainly continue to be the same and for us to expect different results. So, well, in the end, this amount of money that we're talking about, you and I will have to pay. It is not the attorney generals or the president or anybody. It is a cost that has been slapped on Ghana by essentially Ghanaians. And this is what happened. Well, if you recall, at some point in our history, between 2015, 2014, 2016, we had issues with the power outages. At the time, there were some power purchase agreements that were signed. Well, according to John Peter Amewu, sometime on the 20th of September 2018, he addressed a press conference indicating that as of the end of 2016, 14 power purchase agreements had been signed by the Electricity Company of Ghana with about 1,104 megawatts of electricity as estimated. And then also 18 PPAs were also signed by the ECG with an estimated 6,000 megawatts expected. All combined, we're talking about 32. Now, after that, sometime in 2022, there was that decision to have a committee put together to review some of these power purchase agreements that were set up or that signed at the time. After that committee that was made up of the Energy Commission, the ministry itself, and other stakeholders, there was a decision taken to abrogate a number of them, in fact, and also review a number of them as well. Out of that, we understand 26 of them were either reviewed, renegotiated, or cancelled. This particular power purchase agreement is one of the many that were cancelled, according to Peter Amewu, based on a decision that the Attorney General's office had actually recommended that they should take, or it was prudent for government to take, to cancel those PPAs. Guess what? This Trafigura GPGC was one of these independent power purchase or the power producers contracted by the NDC government in the height of this energy crisis that we found ourselves in. The contract terminated in 2018 when the NPP government took over after this audit of the power purchase agreement that resulted in the dispute. Take a look at this. Now, when that decision was taken to abrogate that particular Trafigura power purchase agreement, the company decided to go to court, submitted to arbitration in the United Kingdom. In January 2021, the UK Arbitration Tribunal issued a final award after finding out that Ghana actually breached its contractual obligations to Trafigura GPGC. That decision to abrogate, according to the court in the UK, was a breach of the contractual obligations. It was a judgment that was slapped on us to the tune of over $134 million. And that includes some issues of the cost that Trafigura itself incurred. Ghana only made a partial payment amounting to a little over $1.8 million, leaving a balance of over $111.4 million, almost $111.5 million in arrears. And guess what? It was accruing interest as well. Trafigura then filed another action to enforce the remainder of the award in the United States, to which Ghana entered no defense. And this is something you should think about as well. The government of Ghana entered no defense in this particular instance when Trafigura then filed this other action to enforce the remainder of the award. Because in the mind of the Attorney General, there was no point contesting this. We just had to pay. The courts then gave a default judgment in favor of Trafigura GPGC, ordering us to pay over $111.4 million and mandatory post-judgment interest that also was calculated to the tune of over $30 million. So if you do the addition, It's not just about the 111 million. We're going to have to pay more. So that is what the picture looks like right now. The Attorney General, in response to this, is saying, quoted here, that the award was final and his duty was to ensure that the Ministry of Finance pays. And indeed, the Ministry of Finance has not paid. He's not the Minister of Finance. So really, the burden of this new development is not on him because he doesn't pay. And that's his response to critics who say that, well, he should also be answering questions and taking the blame for this, the non-payment of this arbitrary award, which has not resulted in further costs to us as a country. Well, this is judgment debt. We've had conversations about judgment debt and how sometimes things are allowed to just go through without any action because some people inadvertently benefit from these judgment debt. Well, Dr. Kwabena Donkor has been speaking about it over the period. In fact, since morning, he's joining us again on Ghana Tonight for a conversation. Dr. Kwabena Donkor is a former Minister for Power under the ex-Wa NDC administration. In fact, it was during his tenure that this particular power purchase agreement we're talking about was signed. He's joining us. Thank you so much, Dr. Kwabena Donkor, for time here on Ghana Tonight. And this is the Attorney General's position on it. But I want to find out, first of all, from you why you raise questions and put it directly at the doorstep of the Attorney General in terms of the inaction that has led to this judgment debt, in fact, the increase in the cost that we have to pay as a country.
Let me make this clear distinction. I am not criticizing Godfrey Dame. I'm criticizing the Office of the Attorney General. I want to make that distinction, not the person of Godfrey Dame. However, I am not the one criticizing. If you read the judgment, the U.S. court alluded to the fact that the Ghana legal team or Ghana's legal representative made a very weak attempt at a defense. And therefore, I'm only reiterating what the court has said. So that critique is not originating from me. I'm only re-echoing. And I tend to agree with the critique. You see, I am very disappointed with the handling of this issue right from the word go. I say that for the reason that the minister whose signature terminated the contract said at the time that he sought and received legal advice from the Attorney General's office. If you care to know, Godfrey Dame was then a Deputy Attorney General. So he was part of the Attorney General's office. Then he went ahead to illegally do the termination. And then when we were called before the arbitration panel, our case was so weak that the arbitration panel judged against us. Then on the back of that, the country agreed with Trafigura a settlement plan. Again, the Attorney General and their agents were the lead representatives of Ghana. We agreed a settlement plan. An initial 1 million plus was paid as part of the settlement plan. And then we reneged again. The Attorney General, being the advisor to government, being the lead player in the settlement negotiations, etc., has a responsibility to bring to the attention of the Ministries of Energy and Ministries of Finance the breaches that were perpetuating even against the settlement agreement. And with this, it is only right that the Office of the Attorney General is brought to book. 111 $11 million is not chicken feed. It is serious money and can do a lot in education, can do a lot in healthcare delivery, can do a lot in power supply, and in almost every facet of our national life. $111 million.
Yeah. And I agree with you on that point, and that's the sentiment that many people have expressed, that this amount of money we're having to cough out to pay judgment debt could have been used for other things. But that position that you just espoused, the Attorney General, in his response, is saying that him as a person or his office cannot be blamed for this development, because the responsibility of this settlement arrangement with Trafigura in this judgment debt case was actually to be enforced by the finance minister, not him. He doesn't make payments. That's his response to those who are raising questions about the office itself, like you.
Who is the lead advisor, the chief advisor to government? Which office? In fact, the Attorney General's office is one of the few, if not the only one I remember, specifically mentioned the Constitution of Ghana. That is how critical that office is. It's so critical that the Constitution specifically mentions the Attorney General's office. And therefore, if you are the legal advisor to government, if you represented Ghana at the arbitration, you also have a responsibility to ensure payment. Yes, you may not be the exchequer, but you have a responsibility. If the Ministry of Finance was breaching the agreement, did you bring this to the attention of His Excellency the President? And if you did you bring this to the attention of Parliament? We give you the reverence. You are also the leader of the bar. You have that reverence, that position, because you are the Attorney General. Right. If you cannot ensure compliance with an agreement that you brokered, then you cannot be absolved from blame. Can you?
Well, but you questioned earlier the basis and the reason for this decision to, as it were, cancel this PPA which was signed when you were power minister. Are you saying that the reasons the former energy minister advanced, which he says was upon advice by the Attorney General at the time, for the termination of this power purchase agreement, which has resulted in this judgment, that is unjustifiable?
Right from the word go, I said, look, that I drew the attention when I first heard of the attempt to terminate, that the reasons being assigned are not tenable. For example, one of the reasons assigned in the letter of termination was that Ghana Power Generating Company had failed to obtain the necessary permits from the Energy Commission. If you look at that contract and all other power contracts that we have signed, the government of Ghana has an obligation to assist the contractor obtain all those permits from government. And therefore, if you turn around to say they have failed, when you have an obligation to assist, that will not be tenable in any court of competent jurisdiction or before any panel. And that is exactly what we did. You see, let me state this. That emergency power agreement was the cheapest in terms of tariff of all the emergency power agreements we signed. That is one. Two, it had the shortest duration. It was a 4-year contract. Three, I have heard people say the equipment was not brand new. Was it the only one that was not brand new? No. A good example is the AXA. The AXA plant was not also brand new. We sent technical teams to go and inspect the equipment before they were dismantled and shipped to Ghana. And the technical team from VRA, from ECG, from the ministry who went on both cases said the equipment was fit for purpose. The AXA plans had a 5-year contract. The 5-year contract elapsed, and this government further went ahead to renew the contract, give them another 10 years. So you cannot use the argument that the equipment was not brand new. No one ever said it was brand new. The question, was it fit for purpose? And the overwhelming answer is yes. You see, there seem to have been some parochial interest in all this trafigura business. But no matter the parochial interest, the interest of the Ghanaian state must always be paramount. And that is why I find it difficult to even say I feel vindicated. No, because my nation is losing over $111 million. Remember, there are legal costs associated with all this. If you add all that, it's in excess of $111 million.
That's right. But you earlier mentioned a parochial interest in all of this, which has resulted in this judgment debt that we're having to pay in the midst of all the hardship and the difficulty that we find ourselves in. What exactly do you mean by this parochial interest that you talk about?
The parochial interest I was referring to is there seemed to have been an attempt to deny trafigura operating space in Ghana, particularly under a particular country manager. And that is why I talk about the parochialism. I
see. But I'm going to leave you with this, because right now, there are a number of these cases of judgment debt which raises fundamental questions about why, in some instances, specific actions are not taken to at least even reduce the cost of the judgment debt on all of us, or instances where some actions could have prevented judgment debts from being incurred or being slapped on us as a people. Going forward, what should this development in this judgment debt case inform how government takes decisions on abrogating certain contracts, not just the PPA, but contracts, as we have seen in some cases, could also result in judgment debt?
Well, first of all, government has to eat humble pie. Go to Trafigura. Trafigura is still doing business in Ghana. And I'm sure every business will want sustainability. We can go back to Trafigura, make new commitments, and this time stick to the commitments. So that even if we have to pay this over 5 years, 10 years, we can negotiate that in good faith, with emphasis on in good faith. Going forward, must we allow public officials, either through negligence, incompetence, or sheer insensitivity, to incur such costs together? I would personally want to see the next government, and I pray the next government is NDC. In the unlikely event it's not even NDC, I want to see this and other such judgment debts investigated and public officials held responsible and punished if found culpable.
No, but appreciate your time.